See some people coming online. Morena koutou katoa. I'm Peter Mee. I'm the Assistant Commissioner at OPC, and welcome to the third day of our favourite week of the year, Privacy Week. Welcome also to what will no doubt be the most exciting webinar of the week, because we've got a real treat for you today. We are talking about social media monitoring by law enforcement agencies, and we will be busting the myth that if you're not doing anything wrong, you've got nothing to hide. We know a lot of agencies worldwide and in New Zealand turn to social media to collect evidence and intelligence. Some of these practices are really important and worthwhile, but they come with privacy risks as well. So today we're going to have a good chat about those practices and why it can be harmful for enforcement agencies to access even publicly available information. Now, as a quick disclaimer, our webinar today is a general discussion about these privacy issues and considerations relating to publicly available information on social media and other spaces, and their potential monitoring by law enforcement. We aren't focusing on one agency, but we will talk generally about some of the practices that you see in New Zealand and some of the history around the use of those practices. Now, as we go on, I understand you can submit some questions through our Q&A function on the webinar chat, so please do that. And we'll try and get to a few of these before the hour is out. And now to our star-studded panel. I'll hand over first to our visiting scholar, Rachel, to begin things.
Great, thanks so much, Peter. Kia ora koutou. My name is Rachel Levinson-Waldman. In my usual day-to-day job for about the last 12 years, I've been with an organization in the United States, a nonprofit, nonpartisan organization called the Brennan Center for Justice, where I'm managing director of our Liberty and National Security Program. I have been in Aotearoa, New Zealand since the beginning of February as the Ian Axford Fellow in Public Policy, working with the Office of the Privacy Commissioner, doing research on social media monitoring. So I'm really excited to have a chance to talk about some of these issues today. And I'll hand it to Liz.
Thanks, Rachel. Kia ora koutou katoa. I'm Liz MacPherson, and I'm the Deputy Privacy Commissioner here at the Office of the Privacy Commissioner.
Ngā mihi kia koutou katoa. I'm Joanna Hayward, General Counsel here at OPC, and we're really enjoying working with Rachel during her time here with us. Kia ora.
Great, thank you. Well, to our first question, and we thought we'd start with the basics. What are we talking about when we talk about publicly available information? And I might go to my OPC colleagues first. Liz, do you want to pick up that question?
I'd love to, thanks, Peter. So publicly available information used to be, in the old days, what was reported about you in things like the newspaper, public records, maybe court cases. Those were the analog days. We're in the digital days now, and in the world that we live in, there's large quantities of information available about people that can be sourced from the internet. So what we mean when we're talking about the public domain is information that can be readily accessed by any members of the public. So in the privacy context, it's information about people, obviously. It's their personal information, and it includes whether or not it was intentional or otherwise that information is out there. And it's also regardless of whether the information was released by the person themselves or someone else. So you might be part of a family group chat, a friends group, and as far as you're concerned, that information is going no further than that group, but somebody in your group decides to post it more broadly and it's out there. It's also whether or not that information is current or past information. So it could be information that was posted about you when you were at school, could be when you were at university, could be when you used to go to parties that you don't go to anymore and you'd rather people didn't know about. So anything that's back in the internet archives that can be discovered, all of that is publicly available information. So in other words, our social media profiles, posts, blogs, photos, and it's not just that sort of information. It's also other information available via the internet. So we could be talking about information available from websites and search engines. When citizen journalists or bloggers blog things, public government records that are available online these days, information released by the government under the OIA. All of that information is publicly available information. But now we're starting to get a bit of a blurring in the line between publicly available public information and private information online, and in particular in the sort of lawful space, I guess. So concerningly, there's an increasing risk that with the large-scale data breaches and data leaks that we're seeing, confidential personal information about people is ending up online and available to people who search for it. So what I'm talking about here is information that may have been hacked by a malicious actor, carrying out a cyber attack or a ransomware attack. So an example of that is the recent Latitude Finance data breach, where the data of 1 million New Zealanders over the age of 18 was out there. It had been hacked and it's out there in the public. Or the example recently at Te Whatu Ora, where a disaffected employee decided to leak vaccine-related information about people. That again is out there. Now, it's publicly available, should it be being used? Doxing, that's a form of online harassment. That information, names, addresses, workplaces, personal details, that also could be put out there and available to people. And then we also have situations where, and actually in the case of doxing in Australia, interestingly, the government's planning to outlaw that as part of their updates to their Privacy Act. So all of these sources of personal information can actually reveal individuals' details. And in fact, some of the information that's out there, when you include the biometric information that might be able to be collected about you and posted, might actually tell other people stuff about you that you don't even know yourself. It might reveal information about your health and that you have been keeping potentially from loved ones, but it's out there. So there are lots and lots of third-party commercial tools that are coming online which effectively give the ability for members of the public to get greater and greater access to personal information. And I guess the question there is, just because something is becoming accessible and available, does that make it public and does it make it okay? For example, if you've got a really great tool that does the equivalent of, I'm walking past a house, I see that you've happened to have left the window slightly open, even though you need to keep your house secure. I can open the window, I can get in the house, I can photograph everything that's in your house. Is that okay? How would you feel about that? So I'll stop there and I think we can go on with the rest of our seminar.
Thanks, that's a fantastic overview. And now to the tricky stuff, and I'll put the challenge to you, Rachel, that if our lives are already plastered all over the web and anyone can Google me and find out a huge amount of information about me, then what really is the privacy problem today? Aren't you just getting in the way of the good guys trying to stop bad things from happening?
Yeah, so I think that's a really well taken question because as you say, and as Liz was saying, right, there is a lot of information that is sort of out there that's publicly available and that even, sort of the average person sitting down at a computer could pull up a lot of data. But I think there's some things that are really important to talk about, both when we're talking about social media and when we're talking about sort of the overall use case that we're focusing on here, which is used by law enforcement agencies, right? Because the stakes, kind of to start with, are much higher when you're talking about an enforcement agency, right? It's much different from, a person sitting down. It's an agency that has, the power to investigate, to enforce, to arrest and prosecute, to, potentially detain and imprison. And so I think kind of to start with, the import is potentially higher when we're talking about this kind of access. And then in the context of social media specifically, I think there are a few things to think about. So the first is the way that what's available on social media, especially if somebody has been using social media for a while or uses it for a variety of purposes, and this very much speaks to what Liz was talking about as well. There could be a lot of information out there, right, that could be accessed to put together a quite comprehensive picture of somebody. And that could be drawing from just social media information. It could be combining social media data with other data, right? There are a lot of tools that kind of serve that purpose. And it could be looking not just at, I put up this post or I put up this series of posts, even looking back, but it could be doing kind of network analysis, right? Who am I connected to in a way that social media is really kind of uniquely situated to provide that information. And it's not the kind of thing that people necessarily think of when they think, oh, I'm going to put up this post, or sure, I'm going to, friend these people or connect with these people or accept those friends requests. It's not necessarily quite a voluntary choice to make that broad network information available, but it often is. It often is information that's kind of available to the public or available to law enforcement or to one of these tools that could pull that information and kind of extrapolate and do a lot of data analysis kind of on top of that. The second, which ties into that, all of these are sort of woven together, is how quick and inexpensive it can be at this point to gather that information and to do that analysis. And that's something that the courts in the United States have spoken to as well, that when it becomes so much faster and so much easier to do this kind of data collection and analysis that can reveal potentially sensitive information about somebody, that can reveal something that they may not have meant to share, something that could connect to, something related to their family, that could relate to, sexual orientation, gender identity, religious beliefs, something that they may think that they're not revealing or not trying to reveal, but kind of this massive information can reveal, that's quite significant. And it sort of takes law enforcement out of what would otherwise be these natural structural constraints of deciding, okay, there's maybe an investigation or a criminal matter that's a high enough priority that we're going to put resources into investigating this person, could be following them, could even be doing surveillance, but those resource constraints kind of act as a limit. When you're talking about digital tools, a lot of those constraints fall away because it can be so easy and so fast to do this analysis that it can put a major kind of thumb on the scale for enforcement and investigative agencies. The third, and again, this is related, is finding out information about other people, right? So I may be somebody that doesn't use social media at all or doesn't use it very much, but there could be somebody who is posting a significant amount about me. I'm being tagged, there are pictures of me, right? So there's more information than I even think or am trying to put out there, but can be gathered about me. And kind of in reverse, maybe I'm out there posting information, I'm connected with somebody that, shares views that I don't agree with, but they're maybe posting some of those, on my own page. Maybe those views are going to be imputed to me by virtue of those social media connections. I think that on the flip side of sort of this idea that you can build out a comprehensive picture of somebody is the fact that social media can also be very easy to misinterpret, right? When you're talking about, language that people are using, context, cultural references. And so there can also be a lot of ways to get it wrong. And we've seen this play out in a few ways. So just to sort of pick up a couple of examples or use cases. So certainly in the US, there have been examples of people, often teens, often youth of color, who are subject to deportation proceedings because of pictures online, often on Facebook, that may show them wearing a certain color of clothing or wearing some kind of symbol on their clothing that is interpreted as a sign of gang membership and often has not been. It's been a color of their favorite sports team. It's been the mascot from their school. But in looking at that information, immigration agency decides, oh, this is proof of gang involvement. And so then there are these very, very high consequences. Another example is a British traveler who sent out a tweet to his mates kind of before he was going to travel to the US, saying, oh, who wants to get together before I go and destroy America and dig up Marilyn Monroe's grave? So that was, the Destroy America was slang for just, let's go have a party, or I'm gonna go to America and party. And digging up Marilyn Monroe's grave was a reference to Family Guy, to an animated TV show. He got on the plane, got to LAX, to the international airport in LA, and these tweets had come to the attention of US border officials who simply did not know how to interpret them. They didn't have sort of the cultural and contextual reference points. And he and his traveling partner ended up getting interrogated and deported back to Britain. So sort of comic away, but also, again, these fairly high consequences. And then, of course, it could chill speech and association. and, kind of the important aspects of involvement in a democratic society, that association, protest, dissent. If people think that they're being watched, if people know that they're being watched, if people know that others are being watched, that can have real consequences for how people act. And I think just, finally to sort of tie it into, why are we getting in the way of the good guys? There are an enormous number of very important things that law enforcement agencies here and around the world do. And it's not to underplay that. But at the same time, we know that they're not always the good guys. And we have examples of that, in New Zealand as well, of activists being under surveillance, of, disparate impact of policing on activists, on Maori communities. And so I think that layer as well is important to keep in mind when we're thinking about the kinds of guardrails and the kinds of considerations that we want to keep in mind.
Fantastic, thank you. That's a very comprehensive overview. And can I just remind people who are online, if they have questions, if they can post those using the question and answer function within Zoom rather than the Zoom chat. And Emma's looking after that. Emma here at OPC is looking after that as well. So if you can just post those in there, that would be great. Now, Rachel, you've done a lot of thinking and research both in your career in the US and now in your time in New Zealand about some of the specific practices that underpin social media monitoring. Can you talk a little bit about the ways that police departments go about this?
Sure. So I'll just touch on this briefly. And this is really just sort of broadly speaking, thinking about some of the different categories that might come into play. So the first would be just sort of Googling, right? You could search somebody online and some of the information that comes up could be, tweets that they've put out, could be, a Facebook status update, things like that. And that would be sort of fairly straightforward. The second would be some kind of more sort of specific social media searching. So maybe you're going onto a platform to find information about, a person, a group, a hashtag, something like that. That's the kind of thing it might or might not require, say that, the officer doing that searching have an account on that platform. If they do, it might be using, an account that's sort of identified as a law enforcement account, or it might be using a persona that is not connected, right? That doesn't look at as though it's a law enforcement account. So that's sort of a broad category. There could also be use of what I'm calling sort of false personas or undercover accounts used to connect with somebody more directly, right? So maybe joining a group that somebody is in, maybe connecting with somebody online, right? There's sort of various levels of kinds of engagement that could look like, but, we certainly see that, at agencies sort of around the world, that there could be those kinds of uses, usually depending on the severity of the investigation or the potential offense. There could be a warrant or a court order, right? So, there could be an agency that's saying, okay, we actually need to see, for instance, direct messages that were exchanged between people on a social media platform because they're relevant to a criminal investigation. They would then go directly to the social media platform, right, with some kind of court order in hand. And all of the platforms have mechanisms in place to handle those kinds of requests that are, been sort of overseen by some sort of judicial process. There could also be use of third-party tools. So there are a number of kind of products that are available for sale. This is something that we've seen a lot in the United States, is purchase of these tools that then may do searches, may do analysis. Some of them scrape data and do this kind of large-scale data collection and analysis. And then the last could be account takeover. So actually using somebody's account with their permission, saying, for this might come up in the case, for instance, of investigation of child sexual exploitation online, saying, okay, there's a victim, we need to basically sort of stand in their shoes as we're interacting with people to try to, determine who an offender is or to find other offenders. And so then there would be an officer who is actually kind of, acting as that person online. So that's sort of, I would say, a quick rundown of what some of those different uses might look like.
Great, thank you. And so these are all really interesting and potentially concerning practices, but how does the Privacy Act come into this? Liz, do you want to pick that up?
Sure. So I guess the first starting point for us is that just because social media information is publicly available doesn't mean that the Privacy Act doesn't apply. There is no get out of jail free card just because you've got it from the internet, for example. The Privacy Act is basically concerned about any type of personal information about people, regardless of its source. So regardless of where you got it from, once you've actually collected it, you're responsible for it, and the Privacy Act applies. It includes things like making sure that it's accurate, so subject to the accuracy requirements, safe storage requirements, about how long you keep it for, when you delete it, the ability for individuals to ask for access to the information that you've collected, all of that still applies. So again, just want to reiterate that just because it's called publicly available information doesn't mean that once you've collected it, the Privacy Act doesn't apply. Secondly, the Privacy Act generally applies to anyone accessing personal information for government or commercial purposes from any sources, including public ones, right? So this includes law enforcement agencies like the police. And while the police officers will have legitimate reasons to Google and search people online, including social media, and Rachel's just gone through this, as part of their policing inquiries, anytime they collect that personal information, the privacy principles apply, which means that there are privacy considerations that they need to think through in how the information is collected, by what means, and how it can be used and disclosed. So they need to think about lawful purpose, really. I guess building on another point that Rachel made, the Privacy Act applies to law enforcement collection of personal information through third-party service providers as well. So essentially, under the Privacy Act, public agencies are accountable not only for the information they collect directly, but also for information that they get from publicly available sources and third-party commercial services. So the Privacy Act's principles are a really important check on the justification for collecting personal information from publicly available sources. So the first privacy principle, IPP1, is about purpose and context, and it means that a law enforcement agency has to identify why the information is being collected, even if it was publicly available. And any agency collecting personal information must have a lawful purpose for doing so. The information has to be reasonably necessary for that purpose, and there has to be a logical connection between the law enforcement function being exercised and the information being collected. And this is essentially a protection against overly broad collection of personal information for non-specific purposes. So really important around the use of social information, media information to support a policing function or investigation. The second IPP or information privacy principle I'd like to talk about is means of collection. Here we're talking about fairness. There's also a fairness limit on collection in IPP4. Personal information should only be collected by means that are fair in the circumstances. And we've got a particular focus that came in under the 2020 Act on personal information being collected from children and young people. So we need to think seriously about that. And here at OPC, we've been doing a lot of work around children's privacy, and are particularly concerned about whether children really understand what they're doing when they put that information out there. How do you think about that, collecting information from the social media of children? Do they really mean what they say at that age? You know, there are all sorts of things that can be said about themselves and about others. Yeah, so something to bear in mind. Although taking a photograph in a public place is generally not prohibited, like collecting publicly available information from social media, a thing to bear in mind is that our joint report that we did with the IPCA pointed out that in a law enforcement context, photographs of children and young people is a collection of sensitive personal information that, due to the unique nature of a person's photograph and the strong connection with their identity and their manner and their personhood, needs to be taken very seriously. And in the case of photographs of people's faces, we're talking about our situation here in Aotearoa, New Zealand. It's sensitive anyway, but from a Māori perspective, there are particular concerns about the taking of photographs. And in this situation, we think of this information as being sensitive, and it's generally subject to higher standards of care under the Privacy Act. Last one I want to touch on is IPP 8, which is about accuracy and the risk of misinterpretation. So there, Rachel's already touched on points where there may well be information that's collected from social media which misidentifies somebody as belonging to a group that they don't belong to, or is simply inaccurate. And so IPPA limits the use of any personal information without taking reasonable steps to ensure that it is in fact accurate, that it's sufficiently up to date, that it's relevant and it's accurate for the intended use. It's pretty much a data quality type principle. It's saying, you know, sort of, is this good enough to be used? And I guess, you know, when we're talking about a law enforcement context, we need to think about this from an evidential perspective. So in conclusion, I mean, effectively the Privacy Act does apply, and the critical thing to get across here is just because it's publicly available doesn't mean you don't have responsibilities under the Privacy Act.
Can I have one quick thing on
Please,
top of
yeah.
something Liz had said? Because the point about kind of children's privacy, youth privacy, and especially for kids, sort of, do they know what they're doing on social media? Like, what are the stakes of using that information? I just wanted to add on one piece, and this is maybe a step away from sort of thinking about law enforcement's role itself, but I think it connects to it. There's work that we've done in the States in my role at the Brennan Center and working with another nonprofit organization there, specifically on social media monitoring of K through 12, so especially like middle school and high schoolers. And that's often coming not from police, but from schools themselves. So school districts that are buying these third-party tools to monitor social media. It's often framed as trying to protect against school shootings, which we know have a big issue with in the United States, cyberbullying, and kind of risks of self-harm. So laudable goals, but there have been a lot of the same concerns. So certainly at a basic level, just sort of interpretation, and especially when you're talking about kids' use of social media, right? Even more so, there's going to be sort of, you know, slang and lingo and, you know, in jokes and all of these things that I think are, and I think often kids are especially good at really using language to kind of obscure meaning from, you know, adults or sort of people outside whom they might not want to interpret exactly what they're saying, right? So I think that's always a risk. But then also the impact on sort of growing, developing kids who are learning, as you say, how to act to each other, how to act vis-a-vis the sort of, you know, the outward world, learning how to become members of a democratic society where they're learning to express themselves, learning how to hold views that might be outside the mainstream, and kind of what is the impact of surveillance on that. Certainly impact for kids who are, or are thinking that they might sort of, you know, be within the LGBTQ plus community.
Developing their identity.
Exactly, developing identity. Often these tools interpret sort of LGBTQ related terms as sexualized, and so there might be these heightened impacts, and or they might feel, oh, if I'm being watched even online, I can't find ways to connect with people or communities that might be really valuable for kids who are kind of marginalized or isolated for some reason. So I think just very much to your point, there are kind of even all of these added concerns when you're thinking about how do these kinds of tools and how does this kind of scrutiny play out for kids, understanding the goals that are behind it, but I think it can also have, again, these really heightened stakes.
That's great, and that actually speaks to one of the questions we've got through Q&A about from Byron about do you think social media posts made by users when they were in their young to mid-teens can be used when they are looking for analytical work as part of the screening process before employment. And it's getting a little bit away from social media monitoring, but I think speaks to the, I guess, the sensitivity that we're talking about with young people and actually still finding themselves and not necessarily being held to account for something they said when they were younger. So yeah, I think that's a really important point, and is relevant to social media monitoring generally, I think. Yeah. So Liz has talked about the Privacy Act, but this goes bigger than the Privacy Act. And Joe, I wonder if you want to talk a little bit about how the Bill of Rights sort of works with this social media monitoring issue.
Sure, look, I'd be happy just to make a few comments about Bill of Rights Act side of things. The Bill of Rights Act in New Zealand, of course, it protects and affirms important rights and freedoms for New Zealanders, such as freedom of expression, freedom of association, freedom of assembly, freedom from discrimination. So all really important rights in ensuring a peaceful democracy. From a privacy perspective, the key protection is found in Section 21 of the Bill of Rights Act, the freedom from unreasonable search and seizure by the state. So really that's the primary Bill of Rights lens for looking at the collection of information about individuals. And it's really based on whether the person has a reasonable expectation of privacy in the information. So I think kind of the first question really is, well, what is a reasonable expectation of privacy? And our Supreme Court has explained that this is really directed at the biographical core of information about a person and information that that person would really wish to exercise some control about in terms of what is available vis-a-vis the state. And it's also being described as information that would tend to reveal intimate details about a person's lifestyle and their personal choices. So this is kind of the touchstone privacy formula in the Bill of Rights Act. And when the courts are examining this question, they're really bringing a kind of forensic examination to all of the relevant circumstances around the information collection to figure out, well, what is the reasonable expectation here? So they're looking at, you know, the nature of the information, the place that it was obtained from, and the manner in which it was obtained to try and get to this question of reasonable expectation, because that's so important in figuring out, was this a search under the New Zealand Bill of Rights Act? And one of the really influential factors is the public or private zone in which the information was collected in or from. So the more public the context, then the less likely a person has a reasonable expectation that that information is private. And so the less likely that the information is protected under Section 21. But of course, you know, what's public on social media and what's private is quite a difficult line to draw. And it's interesting to look at, you know, the Law Commission and the Ministry of Justice looked at public surveillance in its 2017 report on the Search and Surveillance Act. So in looking at public surveillance, including social media monitoring, that review did highlight that public surveillance can intrude on reasonable expectations of privacy in some cases, really depending on the level of scrutiny that's applied and the types of technology that are used. And it was pointing out that, you know, public surveillance can impact on the privacy of large numbers of people and people who may not have necessarily been suspected of wrongdoing, as well as the potential chilling effect on freedom of expression, with social media platforms being such an important platform for that. So, yeah, the review looked at two kinds of social media monitoring: the targeted searches to investigate a specific person or a group, as well as the commercial algorithms. And it recognised that this is a really valuable law enforcement tool, particularly in contexts like public safety, and when it's used in a sufficiently targeted way. But the report was flagging some of the risks, so that, for example, widespread monitoring is potentially then likely to undermine freedom of expression. And also that if it's used as a predictive tool, that then starts to get into the concerns about discrimination. So we're using algorithms with particular search terms could heighten scrutiny on some groups. So the review did recommend some caution when using social media monitoring about when to access information and how it's used. And really interestingly, the recommendation looked at the tool of having an agency policy statement for social media monitoring. So this idea was having a level of guidance about the relevant principles to help make sure that this activity stays within reasonable bounds and within the Bill of Rights Act parameters. And it was really building on a tool that's already in use in the intelligence and security space. So we've got ministerial policy statements for the intelligence agencies, including around publicly available information. And that's a nice way of setting out the relevant principles that have to be taken into account, like respect for privacy, proportionality, and respect for freedom of expression. So, you know, we have this precedent use of policy guidance as a reference point. And, you know, potentially this could be a useful tool to make sure that monitoring isn't unjustifiably or inadvertently infringing on protected rights.
Thank you, Jo. And you know, it wouldn't be a conversation about privacy if we didn't mention AI, and it's had a huge impact, particularly in the last year, and I imagine it would have a big impact on this issue, actually. So Liz, do you want to talk a little bit about how AI might supercharge, I suppose, social media monitoring?
When we talk about AI here at the office, we often make the point that it doesn't as much create new risks as to just basically put the existing risks on steroids, right? It's just, as you say, supercharging. So interestingly, we just had what somebody yesterday at a seminar I was at described as a seismic event in the AI world, which was OpenAI releasing ChatGPT 4.0. And interestingly, what somebody else in the privacy space identified was that each time they put out a new edition of it, all of the privacy protections, if you're a user, you've actually added into the last edition, disappear. So you suddenly find that actually if you turned off the ability for your data to be used for training purposes, it's suddenly back on again. So, you know, that's not something that we would approve of here at the Office of the Privacy Commissioner. But getting back to AI, essentially AI allows things that would simply be unthinkable from a manual perspective in the old days, because it just would cost too much. It would take too much time and effort to do, to be just available at the press of a button. Last year, for example, Meta sued a company called Voyager for using automated processes to create tens of thousands of fake accounts that it then used to scrape publicly available data from over 600,000 Facebook users in the space of just 3 months. Now, I think in the way that AI is evolving, 3 months is, you know, sort of so yesterday. It'll be a much shorter period of time than that. But, you know, and we're not sure that that involved AI, but, you know, certainly a significant amount of automation, and AI could be a piece of that now and in the future. I mean, effectively, it is being used for web scraping now. And in fact, I went online last night in preparation for the session to see whether it was possible for me to buy a tool that was an AI-enabled web scraper, and I could if I wanted to. So for those of you who most people will know what web scraping is, but essentially what it means is that this tool goes across all of the websites that are available on the internet, including Facebook and other forms of social media, and effectively just scrapes information from it. And depending on the power of the tool and the way that you instruct it, and these days you can instruct it just using natural language, it can both scrape information, but it also can learn what that website has done to protect against the last lot of scraping. So it basically just learns as it goes along. So AI enables that. It also enables the very large scale analysis of social media. And this includes virtually any language. This morning I saw a posting which essentially said that AI is learning different languages around the world so fast now that even languages like Icelandic, which apparently in the past only around 350,000 people in the world actually spoke it or could use it well enough for it to be interpreted by an Icelandic person as being an Icelandic speaker. AI now knows how to do that. So in Iceland, they've seen a dramatic increase in phishing. People basically being convinced that this is a real offer because it basically speaks in their language. It looks real. So this is another way that information, your personal information, could be gleaned from you and then basically put on the dark web. There's issues about how that information is trained. So AI needs to train itself. Does the software that it's using actually understand the New Zealand context? How is it going to interpret it? Has it been designed to mitigate or eliminate bias? If it's basically ingesting the sort of whole sort of corpus of online data, which reflects all of the bias that is part of who we are as human beings and prejudice, what does that mean about what it's learning? We've got a situation, I remember a situation where last year Instagram's AI auto-translate feature inserted the word terrorist into the bios of any users whose post contained the combination of the word Palestinian and a picture of the Palestinian flag and the Arabic phrase, thank God. So just assumed that these people were terrorists. So we've got a situation, harking back to the point I was making earlier about the Privacy Act and accuracy. How do we know this information is accurate? And I think, and does the AI interpret nuances appropriately? The other point I'd make is AI is getting better and better at mimicking humans, and that that the information that is on the web may not be accurate, and it may not actually be a human being, and the person that you're interacting with could actually be a deep fake, and that information about you could also then be scraped. So some really considerable things to be concerned about, and basically the message here is AI tools can be trained on social media. It can raise and pretty much magnify a lot of the risks that we've already talked about. It's not vetted for accuracy. For example, the case in the US, I think, were the law lecturer or a lecturer at a university who essentially suddenly found himself being accused of sexual harassment because the AI had basically put together a university lecturer with cases of sexual harassment that had happened in other places, and had basically just assumed that he was guilty. And
Yes, basically a pure hallucination.
It was completely and utterly. But this is what AI could do, and this is what would then have been, that information was then in the public space and could have actually been picked up as part of social media monitoring.
And I think just to add on to one piece, which actually wasn't a thing that I thought about a lot before, but I think your point about deep fakes and even kind of a level, I don't know, up or down, maybe even a little easier than a deep fake, but we know that there are lots of bots, right? Especially on Twitter, there are bots sort of producing information, right? So you can imagine a scenario where potentially a law enforcement officer is looking even in good faith to say, okay, I know that there's an event that's being planned. I'm trying to get a sense of how many people are likely to be there, what do we think is the risk of potential violence or some kind of clash. We need to figure out, what resources are we allocating to this to keep people safe. You could imagine a scenario where there's some of that planning or sort of call to action happening online legitimately, but there could be also AI-driven bots that are seeming to kind of escalate the perceived threat level, escalate how many people are going to be there, escalate who's going to be there in a way that is simply not true, but is designed to kind of foment concern or to drive a much more significant law enforcement response in a way that could itself potentially either escalate the risk or kind of change the dynamic, right? So there's that other piece of an enforcement agency itself not using AI, but potentially being subject to AI tools because it can be so hard to detect, even for sort of the best detection tools, but certainly if you're just kind of sitting down and looking at posts, you may have no way of knowing kind of what's legitimate or not.
Yeah. And I think this is the difficult job for somebody who's in law enforcement. Here you've got a tool which ostensibly looks like something that could actually be used for good, could help you identify, and potentially prevent, issues. But at the same time, we're living in an age of disinformation, of information being created which is not accurate and is deliberately inaccurate. So how do you think those things through?
Absolutely.
What we've just been talking about actually has hit on a couple of questions that have come through, particularly from Angie about what are the dangers of AI creating fictitious personal data that can be used in these monitoring tools. I think we've talked about that. There's a very real danger of that occurring. And there's also a provocative question about is OPC thinking about an AI code in terms of managing some of the risks from AI? And I wonder if that sort of speaks to maybe a broader importance about developing safe frameworks for the adoption of AI. And that's a bigger problem than just us. But what do you think, Liz?
So first of all, we have actually put out some guidance. We put out, the Privacy Commissioner put out his general expectations about the use of AI and privacy in May last year, and then followed that up with some specific guidance around AI and the information privacy principles in around December. But what's really interesting is that when you look at the research that's been done about particularly government use of AI and the importance of trust, the importance that people can actually trust that this is being used appropriately, there are three main things that come out of that. Is that for people to trust that AI is actually that the benefits are going to outweigh the risks of it and the government use of AI, it's clear rules and safeguards are critically important. So it goes to whether in how we think about the Privacy Act, whether it's strong enough in this space, and other regulatory tools. The second point was transparency. People really want to know that AI is being used, what it's being used for, and the nature of the AI. And the third thing was a human in the loop. Human oversight and governance is critically important. So that's just for human use of AI, government use of AI, but this is an evolving space. We are at the very, very, very early days of artificial intelligence and what it can do. And from our perspective, the Privacy Act is, it's flexible. And it's technology neutral, but we're seeing some risks that are evolving at light speed, and so there is the need for us to ask the question: are our current safeguards strong enough?
Great, thank you. And we've got a question here about terms of service of some of the platforms. And we've had quite a few questions come through on the Q&A as well about the expectations of privacy if you're on, say, Facebook or Snapchat or things like that. Some of the questions are, can you expect privacy if you're on some of these platforms? And are some of the protections that are already there in terms of not sharing the information onward to third parties, or if photos and messages are deleted once they've been viewed, such as is the case with Snapchat. Can you talk a little bit about that, Rachel, the terms of service?
Yeah, sure. Let me touch on just a few different aspects of that. So, one of the interesting things on a platform like Facebook is that Facebook has actually rolled out a quite significant number of privacy settings. So if you're on Facebook, you can't hide literally everything. There's sort of like a core set of data that's going to be available to basically anybody who's looking. So it'll be your name, your profile picture, a couple of other basic pieces of information. You can actually fairly significantly lock down a lot of the rest in terms of the rest of your pictures and friends lists and posts and all of those things. And so I think there is then kind of a presumption of at least some measure of privacy, maybe not secrecy, but privacy. Now, somebody could, copy paste a post that you put up, something like that, and share it elsewhere. That would be more of a breach of norms than a breach of sort of the settings per se. There might be something in the terms of service or the kind of community expectations, right? So I think you do have to sort of act on the assumption that even with those privacy settings in place, there certainly could be something that is shared onward. But you can take some measures as a social media user to, there are different, Facebook is sort of known as like a walled garden, right? Where it's easier to build those walls. On some other kinds of platforms, it can be a little more challenging. On something like Snapchat, right, where messages disappear automatically or within sort of a set amount of time. There's actually an interesting case coming out of the United States, specifically looking at Snapchat, because it does have that affordance, right? Unlike most other platforms where you sort of expect your information is up there until you take it down. And so, especially if it's public, somebody could look quite a ways back and find old posts. Exactly, it sort of combines both the platforms and some of these law enforcement uses. So this is a case where a law enforcement officer had sent a friend request or a connection request to somebody on Snapchat. That person had accepted it, not knowing that it was a police officer. And then the officer had been able to see the snaps that this person was putting up. The officer had no particular suspicion of criminal activity, was just sort of curious about what this person was up to. So they ended up putting up something that reflected criminal activity. This went up to the Massachusetts State Supreme Court. That person argued, look, this was a violation of my reasonable expectation of privacy because I had no way of knowing who this person was. And I'm using this service literally because, my post disappeared. And the court there said, well, you have already said, kind of as part of the case, you said you don't always kind of vet the people whose friend requests you accept. So to some extent, you have taken that risk on yourself. But the court kind of diverged from what the doctrine had been, which is that you always take the risk. If you're talking to anybody or accepting a request, you always take the risk in the United States that they could be a government agent, could reveal information to the government, and said, well, on this kind of platform, if you were actually really careful about the friend requests that you accepted, but this one was kind of set up in a way to slip by those defenses, you might actually have a reasonable expectation of privacy there. And I guess the two other quick things to touch on in terms of the platform. So as I said, most platforms do have, portals for law enforcement. And the other thing is that most of the major platforms have bans on scraping data, right? So these third-party tools that kind of traffic in scraping, and not all of them do, but I think probably a lot of them do, those are violating the platform's policies. Now, there could be important reasons to scrape for academic purposes, and this is really a big part of the discussion is, should there be a total ban on scraping? Because it can actually be really important for research. But in a law enforcement space, I think there are real concerns about that, and that would violate most major platforms' policies.
Yeah, on Meta, I'm having a personal battle with Meta at the moment. For those of you who use it, you will have seen that an AI assistant has appeared in your search bar.
Indeed.
I don't want to have AI in my search bar, and so I asked it because can I turn you off? And the answer was, no, sorry, I don't have an off switch. And I've discovered that the best you can possibly do at this point in time is mute it. You cannot turn it off. And so if you were happening to use that search bar, what is Meta's AI doing with what you're searching for? And how is it connecting that with what else you've got on the page?
Great. Okay. Interesting. I haven't talked to my one yet, but maybe I should. We've had a few questions about a right to be forgotten or a right to erasure, depending on how you phrase it. And I guess, it'd be really interesting to explore whether a right to be forgotten would be a useful way of addressing some of these concerns, but also still acknowledging that there are legitimate law enforcement purposes around social media monitoring, and would a right to be forgotten potentially get in the way of that? I wondered, Joe, if you wanted to pick up.
I think it's a really interesting point, Peter, and I think the right to erasure is something that the office, the commissioner, has been thinking about. Is one of the important rights that might help strengthen our framework. But I think the discussion we've been having, and in this context, it gives it kind of particular resonance. Because I think one of the things we've been talking about is, look, you might be taking a current snapshot of something that's happening right now. The intensity of the scrutiny changes if actually you're looking right back, a bit of a time travel machine to collect up everyone's historical data over years and years. And whether something like the right to erasure might help bring a little bit more control for people to say, well, look, that stuff I did as a university student, that was my development period. I don't necessarily want to have that all following me around for the rest of my career.
Any other thoughts on right to be forgotten and its position in this conversation?
Not for me.
No, okay, thanks. And we've got another really interesting sort of philosophical question here around is the use of natural justice principles offering an individual a right of response to identified concerns a useful mitigant to privacy concerns, or is it too late from the point of the Privacy Act at that point, which I think is something we've sort of grappled with internally a little bit in terms of, do you wait for the harm to occur, or do you build the right standards to beforehand to get ahead of the harm? And I think AI in particular is testing that. Do you have any thoughts on that? Maybe Liz, I'll come to you.
I think the issue is does come down to when the harm occurs, and particularly in the world that we're talking about now, you may not know. You just simply will not know that this information has been collected about you and is being used in different ways. You won't necessarily have the right to challenge, right? Before a view is compiled about you. So, I mean, obviously, in terms of once the police or whoever it is who's having a look at things. Sorry, I just got distracted by something on the screen. Once the police are actually engaging with somebody, then obviously the principles of natural justice come into play there when you're having those conversations. But I guess the critical thing for us is how can we ensure that people's rights to privacy, their rights to, as we discussed before, develop their identity in a way which is allows them to grow and to change, can be protected, and I don't think that that an individual is always in the right place to do that, which is why we have thought really hard in the biometric space, for example, about about consent, because some would argue that if you essentially say nothing can be done without the consent of the individual, that's actually it's a really empowering the individual, and on the surface of it, it looks like you're really giving that person agency, and we're not saying that there's not a part a place for that. But in our digital world, so often consent, if it is being used, is eroded away by exceptions, and that the individual may not actually even know what they're consenting to. You know, in the rush to get access to something, they don't realise that actually they're consenting to their information being used by many third parties, which of course then means may well become publicly available.
Great, thank you. And that actually is our time. It's 10:30, and thank you so much for everyone online who's engaged with our session today. That's another myth busted. So we're doing well this week, and a really important discussion. And thank you to the panel for a lot of fun. And yes, look, I hope you engage with the rest of the sessions through the week. And I'm sorry that we couldn't get to all of your questions, but thanks so much for joining us today.
Thank you.
Kia ora.